Good afternoon, everybody. My name is Harvey Silverman. I am a judge of the Los Angeles Superior Court. I've been on the bench since 2004. I sit in Pasadena. Okay, Lynn and Mary Catherine asked me to do some sort of introduction about the evaluative process, and so I thought I would give you my very, very quick version of I call them my who, what, when, wheres, and whys that I end up getting clinicians involved in 730 evaluations or other various and sundry things that I have them doing for me. Why and when I would order a clinician in or an evaluation. I'll consider a stipulation to a custody evaluation when there's been some sort of prima facie showing that there's a clinical issue involved. And those can range anywhere from substance abuse to mental health issues to special needs of children, but I have to have identified to me some sort of clinical issue whereby I can utilize your expertise. I will not order a custody evaluation because it's really, really hard to decide. I'm not looking for a clinician to come in and to help me make that really hard decision, because that's my decision. And if there is no clinical issue involved, no matter how hard it is, I'm going to make that decision and not kind of throw it in your lap. I wish I could say that that was always the rule. We have on the bench, I know in Los Angeles, many judicial officers who are new to becoming judges and who are also may have been judges a while but maybe new to family law. And they may come face to face with custodial decisions that are just those really, really hard ones. But they don't necessarily have clinical issues involved, but they're really, really hard, and boy, would it be great to have somebody there to help me make that really, really hard decision. And so you may be faced with being called upon to do that when there are no clinical issues, just a really hard call. So if that ever happens to me, then I ever put you in that spot, what I hope you'll do is report to me, well, Judge, there are no clinical issues here that would impact the parenting plan. This is just a really, really hard call. In other words, throw it right back in my lap, because it's inappropriate to go to you in the first place. If you have an inexperienced bench officer, you might want to add to that a little bit of guidance as to the kinds of things that they may want to look at to make those really, really hard calls a little bit easier and just sort of help them through the process. Now, who do I appoint? Well, I always try to get a stipulation. And if I can't get an agreement between the parties as to who's to be appointed, these are for 730 appointments, then what I'll do is I'll ask each side to submit a letter to me. It's a joint letter, not identifying who's recommending who, and they can include one or two names in that. And usually they can include their CVs, their locations, their costs, and their availability. I had a really interesting talk last night with some evaluators explaining that I never put a time limit on when an evaluation has to be done, but I often inquire as to when it can begin. So availability is something that I'll look for in making the choice. What do I put in there? I give very specific instructions on all my cases as to what the clinical issues are, who I want spoken to, what collaterals I want spoken to, and what the goal of the evaluation is. I can't promise you that that will always be there. I can't promise you I'll do it all that well when I do it, but what I never mind is the evaluator speaking to the attorneys and asking for clarification on issues. What is that you want me to do? What is the goal of this? Who are these other witnesses? Ask through the lawyers. Happy to tell you, if I haven't done my job well, so it's not clear to you in the order of the court, ask for clarification through the lawyers. Don't call me up and ask for clarification, as much as I'd like to talk to you about it. But there are ways to get it, and I am totally not offended by somebody asking for clarification, not at all. Well, where should this all lead to? I don't know. Wherever the reality of the situation is. I'll accept pretty much any clinical finding as long as that clinical finding somehow or other can jive with the clinical data that you've uncovered. There shouldn't be any surprises at the end. I should be able to, pretty much reading your data, know what the recommendation section is going to going to tell me. Now, when we were talking about some of these things, it was funny. I started talking to Lynn and Mary Catherine about the fact that over the last couple of years, the kinds of issues that are coming to me to decide have a distinctly medical or clinical slant to them. I mean, I'm deciding now whether children should get vaccinated. I'm deciding when children should be weaned. Things that I often turn to the litigants and I ask them, do you really want a stranger making those decisions? Perhaps this is better for you to figure out some other way. But if they can't, we have all of these kind of interesting clinical issues, some of which can be answered by a 730 evaluation, and some are just not appropriate to be answered by a 730 evaluation. And my colleagues and I kind of jived on this and sort of developed these various scenarios and coming up with different issues which are clinical in nature and are routinely now passing through the family courts to be digested by the bench officers and the lawyers and to be ruled upon. So we've gathered some of them together, and we're going to talk a little in the next hour about how they work themselves through from the lawyers to the clinician to the judge. And hopefully you'll find it interesting and ask a lot of questions. So I'm going to turn it over to Lynn now.
How many mental health professionals do we have in the room? How many family law lawyers? All right. And is this? And do we have just our one judge here, or do we have more than one judge? We have a couple of judges. You can raise your hand. We all know you're a judge. One of the most important things about all of the brilliant work that we've seen and heard about how to recognize the quality of research and understand that just because somebody got to you first with an article doesn't mean that that article really accurately presents the state of the literature. And one of the things that I've learned as a mental health professional and an expert in these cases is that, there are, not these two particular judges, but there are some newer judges on the bench who you can flim-flam once. But if you do that, sooner or later somebody's going to tell them that, the research doesn't really massively say whatever somebody told them that it said. And not only are they going to know now that there's a greater balance in the literature, or that there's other more compelling research on the other side, but they're also going to know who's been in there trying to flim-flam them. And most of the judges that I know remember that sort of thing. So it's always more comfortable for those of us who really believe that there is a piece for solid professional information in these decisions to present it as Marsha Klein Pruitt talked about last night, to present it in an objective and balanced way. And I always try to make the case to my attorney clients that in the long run and even in the short run for this client, it may be a better option. But one of the biggest things we want to talk about here is that this science does not just belong in evaluations, and it does not just belong in the expert testimony once the case is litigated. And our friend Judge Gould-Saltman made that point last night when she said that if somebody is presenting to the litigants and counsel in a balanced way or in a really informative way the information about what the science tells them, you may have someone who emotionally is in a place where they're not going to listen to any of that, and they're just going to go to the Father's Rights or Mother's Rights website and they want to litigate. And then hopefully they're going to run into a judge who's not going to give them everything they want, and they're going to then come back to problem solving. But sometimes there are interventions that judicial officers can put in place or that attorneys can stipulate to with their clients that make a better use of the scientific research that we have. Give your clients, each of you, time to resolve the issues that your client has come to you with in your office, and allow them to make some of the decisions themselves or come to an agreement themselves further down the line. And if they don't come to an agreement, then at least you will have attempted to solve the problem in another way, and you'll have all that great data to present to Judge Silverman about all the things that you tried and what happened with it.
The model we're going to use, we have 3 vignettes that are in the materials, and we're going to start with the case coming to me, and where am I going to go with it? Am I going to court? Am I going to go talk to Lynn? Where am I going to structure it? So I don't know if the first vignette, I don't know if everybody has it.
Do you all have it? Okay.
I can read along. 19-month-old Johnny and his 4-year-old sister Sally need a parenting plan. Both are having difficulty with transitions. Father alleges mother is limiting access to the children and interfering with the critical development of the children's bond with their father. Father believes his parenting time should be increased to include overnight time with the children. Mother has read that children should never be separated from their mothers before the age of 5. Each parent has brought an article from a website to the court, suggesting that science supports that parent's position. Father states he has a room set up for the children where they have taken naps during day visits. He states that both children used to transition easily to father's care, and that Sally sounded excited about spending the night at her father's house, but is now expressing reluctance. Father states that both children cry during transitions, but settle quickly after mother is out of sight. Father alleges that mother is influencing the children against him. Mother states that Johnny is still breastfeeding on demand, and father is threatening to disrupt a crucial bonding activity. Mother distrusts father's parenting and believes if his parenting were adequate, the children would not be reluctant to go with him. She seeks a full custody evaluation. Father is only willing to agree to the custody evaluation if there is a step-up parenting plan in place. Father believes the evaluation process will cause him to lose precious time in parenting with his children. Father believes that Johnny may be ready to be weaned, but is willing to feed Johnny breast milk if mom wishes to provide it. So Dad comes into my office. Is the first thing I'm going to do to file a request for an order from the court? Probably not, but I'm not going to wait very long.
Lucky me.
So what order are you going to request? Because Dad doesn't want the custody evaluation. So what order are you going to request?
Well, I'm going to request that there be a parenting plan put in place immediately, especially when you're looking at an 18-month-old child who isn't spending a lot of quality, according to Dad, isn't spending a lot of quality time. You have, from the hypothetical, you don't have a set custodial schedule. You have mom in control of when the children are spending time with Dad.
With the video camera and her parents standing by, and On the other hand, Dad is, we just had one of these on our local family law listserv, which is really interesting. Somebody putting up that they had a baby daddy flying in who had, the baby wasn't born yet, and mom and dad had a 3-week relationship, and they were proposing a parenting time schedule that was pretty reasonable in terms of the parent spending time with the baby during the first 9 months, and then was going to flip over, like a light switch, into a 2-2-3-3 overnight plan. So we don't know how reasonable Dad's expectations are either in this scenario.
Right. And part of my job as Dad's lawyer is to manage his expectations, and to perhaps, as an advocate, when I'm sitting down with him and trying to fashion what that request for order is going to be when I see the court, coming up with something realistic that is consistent with the child's developmental needs, and which I think the court will accept as a reasonable plan. Because for Dad here, going to the evaluation process in some respects could be getting no relief at all, because mom is just going to push off the decision as long as possible until a mental health professional has stepped in.
So what are you going to do first?
What am I going to do first? What I'm going to do first is sit down and see if I can get the other lawyer to agree to something by way of stipulation. And if I meet resistance, I don't know how, we have a situation where we have siblings with 4-year-old, we shouldn't be having problems with the overnight so much. 18-month-old, a different issue, and you have the breastfeeding issue. So I'm going to talk to Dad a little bit about having to accommodate a schedule that's going to take into account the fact that mom is still breastfeeding.
Now, you're going to go first to Judge Silverman or to...
I might have a conversation with you and think about how I want to position it. But I think if I'm representing Dad, I want to make sure that I'm taking some control of the situation, because my sense is the custody. I'm not hearing any serious parenting concerns being expressed by mom, other than the children are having difficulty transitioning.
And I don't want to send the kids.
And I don't want to send the kid there. That, to me, I'm not hearing anything that is a parenting issue. But as we discussed before, just over, this might be a different scenario if dad comes to me and mom's not allowing custodial time because there had been an incident in the first 6 months of the child's life where dad had dropped the baby or neglected the baby.
Okay, should we put this in the context of the research or any comments?
Well, of my judge colleagues here, how about on the list of hard decisions when we're dealing with infants? And we have all the clinical issues of breastfeeding and attachment and to overlay on the normal and regular difficult custodial decisions that we have to make. This area is one that either through urban myth or various bits and pieces of clinical, ephemeral information that floats down to me, that I get enormously conflicting evidence on, clinical evidence on what's appropriate, how appropriately to deal with, a 1-year-old who may or may not still be breastfeeding, or in some cases a 3-year-old who may or may not be breastfeeding, who has to go back and forth between a parent to maintain bonding and attachment, which are terms that are thrown at me by clinicians and lawyers left and right without my really having a firm sense of what either of those terms mean, to the point where it's daunting to have to try to make some of those calls with all of that sort of coming at you, and coming at you not from a harmonious situation, but from a situation that's ripe with conflict and poor communication and limited resources and all of those other things. So are you coming to me with this?
I am going to, if I'm not able to reach agreement with the other party, yes, I'm going to come to you with this, because if mom is being withholding and I'm not going to have an order in place, I think I do have to go to court and get something in place.
Well, one of the first things you probably need to know, though, before we do that, and that's for all of the attorneys to know, is the difference between urban myth and reality. And I would refer you all to Marcia Klein Pruitt's research, which is the most solid in terms of methodology, in terms of her chapter in Leslie and Kathy's book. She's got a randomized controlled population. They've tried interventions. And we had published in the widest circulation of the newspaper that goes to attorneys and judges in our state. We had somebody publish an article with, 14-point headlines that said, quote, "Brain science says that children should never be separated from their primary caretakers before the age of 3. Now, first of all, I'm married to a radiologist, so he knows what fMRIs can and can't tell you, and they are laughing really hard at some of the interpretations that we're drawing from fMRI studies. That's one of the things you need to know. fMRI is functional magnetic resonance imaging, and it is what is being used in some studies to supposedly provide proof of what children's brains look like that are based on whether or not they have overnights with one parent or the other. In some cases, when they're talking about increases in stress level and cortisol and whatever, there is some science behind it, but those things all have behavioral correlates. You don't need to dive into the weeds of having people argue about brain scans to figure out some of this. The research generally says that where communication is poor, overnight visits are a bigger risk, so you need to put into place some kind of mechanism to allow for communication and consistency in the infant schedule. A 4-year-old should have been able to make a supportive transition, but in the presence of a screaming 19-month-old, may or may not have been able to do that. And for a 19-month-old to be having problems with transitions is like, yeah, and? I mean, the fact that the 19-month-old is having difficulty with transitions is a definitive diagnostic sign that the child is 19 months old, and not especially a lot more than that. And then there are the things that Judge Silverman's pointed out that were also pointed out last night, and Marcia's addressed as well. that if you allow a situation where dad doesn't get quality time until the child is 3 or 5, you may be introducing a permanent handicap on the father-child relationship, which we don't know all of the things that we would like to know about the 0 to 3 period, but we know a lot about what happens when fathers aren't involved later on. So, and the last thing is, where parental cooperation is higher, you get better results, which means you may want to throw in there some interventions to try to create that. And the last thing I'll say in sending this back to see what the judges can do with this is that I do understand, I think all psychologists understand, the issue that judges face in terms of not rewarding bad behavior. So if you have a mother who has been systematically thwarting dad's attempts to have time with his child, what do you do with that?
Well, that's part of the issue. Is in this particular case, she's thwarting the attempts, and she's attempting to bring in social science, which supports her actions. When to wean children? I mean, I get that all the time. Judges, have you made that decision? When? I mean,
not to wean, but certainly to deal with a situation where mother is still breastfeeding and there's an overnight and the mother saying absolutely not.
So the comment was that His Honor would put in a plan that you would put in a plan to have a step-up visitation, and if mom wanted to continue breast milk, she would pump, and otherwise she would need to do something.
Certainly, we don't see, at least in our court, a lot of really young kids, because if there's going to be that much conflict, it probably takes a year or so before much is going to get to court with experts and that sort of thing. But in an early application, we might see this. One of my first questions would always be, so what's happening with childcare? I mean, is mother actually leaving the child in the care of somebody else while she goes off to work or to school or something like that? And so, you need a whole lot more background before you start weighing in to crafting something on an interim basis before you start really getting going.
And that's a really good point, because one of the issues on which we really do have good science is that exhaustion impairs parental functioning. Exhaustion impairs basically most kinds of functioning. So that's one of the problems with these broad statements about never separating a child from their primary caretaker before the age of 3, is that we are guilt-tripping an entire generation of parents who are not in child custody cases and are now being told that they're screwing up their child if they sleep. And anyone else who's worked in a dependency situation and has seen shaken baby syndrome knows about the correlation between exhaustion and bad things happening to young children. So that's a really good point, that we need to know what's happening now in terms of relief to the parent.
Yes.
It's because we're recording. I think that one thing I'd want to know too is if the oldest was breastfed, how long was he breastfed, and is mom manipulating the situation to help her case out?
Yeah, all really good questions. And oftentimes it boils down to situations, well, she can't pump for one reason or another. The kid's about 1. When is it best to stop? I mean, because invariably that's the one that doesn't get mediated, that ends up in our laps, where there are no the easy exits off the freeway. So it's headed straight, for you. And this is where often the clinical information is vital. The last time I had clinical information in the courtroom was about 1.5 years ago, and it was basically that after 12 months, all of the immunity factors have transferred properly to the infant, and that any other choice to breastfeed or not is a choice for other reasons. That's the last thing I got. Is more going to make a difference in what you present to this judge who knows more than 90% of the time?
No, because my kid here is 18 months old. I mean, from the standpoint, yes, it is from the, I think, regardless, if I have a mom who is, at some point, if you're 18 months in, you have a 4-year-old you have to get some set plan. And if you're leaving mom in charge of the plan, there's going to be no plan. And I do think, if this is a mom who's leaving the child in child care for 10 hours a day, but somehow dad can't have the kids overnight, that's significant to point out. And it's not in the variable. It's like, okay, you'll leave your child with a third party, but dad can't have them in the evening. And if mom's one of the things I will talk to my clients about when they're younger and you're still breastfeeding and you're in that first year, I do have to counsel them, look, there may be an issue with this. It's not about the duration of time, it's about the frequency of the time. And so mom can't get everything she wants. It's like, okay, you're not going to get your overnight, but maybe you're going to see that kid 5 days out of the week during some prime time when mom wouldn't otherwise, when she's out of work, you're going to get that time. And you'll see whether that tips the balance for mom about whether this is really about the breastfeeding or whether it's about withholding the child.
Well, some of the breastfeeding issues, the reason we can't go with 7:30 evaluation would take too long. And that's one of the things we're kind of talking about is how lawyers would use clinical evidence on this issue without just saying, well, let's order an evaluation.
Right. And we had talked before, to a certain extent, I think what lawyers often overlook is we don't have to have a custody evaluation in order to put on expert testimony about a clinical issue. Everybody thinks that only comes in the context of a custody evaluation. If I wanted to put on medical or psychological testimony on a discrete issue, there's nothing that prevents me from hiring a professional who I can qualify on the stand. They have the credentials to speak on that issue, and they can offer an opinion on the issue.
Okay, so let's say you call me and you ask me if I will consult with you about it. If we could just get the tape up here, then we can move it back and forth better, and I'll steer you short, okay?
Sure.
So you're gonna call me and ask me what then? What I think you should do, or what I'll testify to?
Well, at first I'm going to ask you what I think we should do, because I don't think as a lawyer I should come out of the box deciding what I want my expert to testify to until I know what they think.
And now, like as was discussed last night, I have a very limited window in which I can give Mary Catherine advice before I have to pick who I am. I have to decide, or she has to pick who I am. She has to decide pretty quickly whether I'm going to be a consulting expert or a testifying expert. She can ask me, a few questions early on, or, in other types of cases, and give me documents to review, and then I'm going to lay out the options for her. But one of the things I'm going to say is, because this is what I never see happen, is what do we have in place to get from here to there? If I'm the strategist in this situation, I'm going to advise Mary Catherine against going, particularly to any of the judges who happen to be here today, simply requesting a step-up plan. That if Joan Kelly told us all in Chicago that mothers mistrust fathers' parenting, even in intact families and particularly in separated families. And one of the reasons both parents are important is that they may have different styles, right? So I'm going to say, if all you do is go into a sophisticated judge requesting a step-up plan, you're setting yourself up for the step-up plan to fail, and for any distress in the child to be interpreted as the step-up plan failing. You need co-parenting education. You need somebody to set up a procedure for those transitions. You may want to start talking about whether your 4-year-old should be in preschool and should be picked up by the father at preschool with a separate kind of transition to or from the third party for the kid. You may want to talk about parenting education. You may want to talk about stipulating to a neutral whose job is to sit down with the parties and educate them.
When you say you may want to talk about it, who are you talking to?
I'm talking to the
lawyer.
I'm talking to the lawyer.
Okay.
And if she wants me to be a testifying expert, what I'm going to say is the same thing in a slightly different context. I'm going to say, well, yeah, I can go in and talk about the importance to father-child bonding, but father-child bonding. But I'm also going to have to say that requires sensitive parenting on the part of the father, and it requires supportive transitions, and it requires all sorts of behaviors on the parts of both parents in order to make that work. And a smart judge or a smart cross-examining lawyer is going to ask me what needs to be done before we let overnights happen.
So let's say we change this a little. I have a 6-month-old child, all right? And 4 months ago, father was visiting with him and dropped him. He wasn't injured, but mom panicked, and she hasn't let him really see the kid outside of her eye shot since. All right? And all the time, father is reading on the web that every night he spends away from his child, the less able he is to attach long-term and have a long-term successful relationship with his child. All right? So, Mary Catherine, that father comes to you, and we've got breastfeeding as an issue. Now we've got attachment issues. And we have, as you said, a very sophisticated bench officer, but nonetheless, one who's certainly not a clinician and not up on this kind of advanced clinical theory about development and things such as that. No.
Just, a parental, it could happen, it's one of those that could happen to anybody.
Correct.
Right. So, if I'm presented with that situation, obviously I realize mom's going to have the episode with the child at 3 months is going to have some legs. I can't ignore it. I can't dismiss it, even if it was a mistake. I have to have dad do something. If I'm going to go in and see the judge, I can't ignore that issue. I have to find something for him to do that's affirmative, that looks like he's addressed that concern. So whether that's me telling him he has to go do some parenting classes and get the education that he needs to confront mom's claimed concern about his parenting ability, then I'm going to do that, because I'm going to get out and be defensive about it and address it and say, she's expressed this concern, and instead of getting into whether the concern is justified or not, it's like, okay, there's a concern about our child. So what I'm going to do is I'm going to get this additional education, and how I tend to sell that to clients is to say, look, it can't hurt. And I'm not saying you did anything wrong, but if you step up and you did that, then you've taken that argument out of their hands. So that might be what I would implement that immediately. Am I going to wait until after that 6 or 10 session parenting class is over before I file my OSC? Probably not. If mom is withholding because at 6 months there is a concern. The longer the time passes between the time my client dad is spending time with the 6-month-old and there's the double-edged sword to me. Mom is complaining that dad doesn't have parenting skills. I don't know how people get parenting skills unless they start parenting.
Let's say mom's argument was a clinical argument.
Okay.
All right. Now she says, all right, he dropped the kid. Yeah, we can take parenting classes. We can do all of that. But, I've read that the child for the first 3 years has to maintain the majority of time and all the overnights with the primary custodial parent. And on the other side, you have dad saying, wait a minute, I have all this data indicating that unless I'm in there with overnights and seeing the child like 3 or 4 times a week, even in short bursts, that I can't attach to my child and I'll lose the ability to parent for a lifetime.
Right. Then I'm going to try to figure out a way to bring to the court's attention the literature on attachment, whether I do that by attaching the literature, whether I get somebody like Lynn to provide testimony about the literature on that, whether I have that same expert attack what I think the fallacies are in the research being relied on by mom about the fact that children shouldn't be out of the care of their primary caretaker for the first 3 years. I think I'm going to confront that issue straight on, but I don't think I'm going to wait for a custody evaluation to do it.
Because it's too long.
It's too long. It's going to
And
here's my question. Are you going to use that language? And I want to ask the bench officers in here, including you, because I'm lately have been really struck by 2 things. The disparity in which bench officers and how they respond to the word attachment, and the use of the word attachment as a phrase to represent so many things that I'm not sure even I know what it means. So as a tactical issue for the lawyers, I don't know whether it's more effective to use the word attachment in the hopes that you scare the bench officer, Because for me as a psychologist, I'm going to say, what do you mean by that? And I'm going to talk in terms of functioning and outcomes for children. I'm going to talk about relationships and the skills parents have. I'm going to take the term attachment and I'm going to translate it into English. Because once you translate it into English, then, yeah, you do begin to focus more on dad having time for multiple caregiving activities during the day. And you start to begin to look in English at whether dad having nap time is really sufficient or whether at certain points the young child, especially at this age, needs to experience going to sleep supportively and getting up supportively with the parent. And you're also going to look at whether dad is willing to let mom tell him anything. Because that's the other side of this here, is that consistency in caregiving routines, once again English, is really important. So if dad is now so angry that he's not about to listen to mom talk about anything about what time Junior eats or how they deal with bedtime or any of Junior's likes and dislikes, that's going to be a factor to consider. As on the flip side, it's going to be a factor to consider, if each parent also needs an opportunity to develop his or her own rituals with the child. I don't think it may well be traumatic not to have the teddy bear. You may need to even ask the judge for an order temporarily that the teddy bear transition with the child. But very quickly, if I'm working for you, I'm going to tell you that kid needs to go to bed at dad's house with a teddy bear and another stuffed animal. And that dad needs to be building, because mom's not necessarily going to obey that. And I've yet to see a judicial officer who wants to do an ex parte hearing about the teddy bear and whether it's going back and forth. So your parent better be introducing, the stuffed platypus right next to the teddy bear so that when mom doesn't send the teddy bear with the kid has developed an attachment to something else.
Well, all I can say is I don't know how it is in your court, but I know that Diana and I are seeing more and more cases with infants, and this clinical conflict of the bond with the primary parent versus attachment and sufficiency of attachment to the secondary parent, they're at clinical odds with each other, and it makes some very difficult decision-making, and it extends even beyond the parents. A real-life case that I haven't had in front of me recently was parents had agreed on everything, finally, except who was going to be the caretaker for a 27-month-old child. Why would that make a difference? All right, well, the child had the same caretaker since birth, child care provider since birth. Only that child care provider was a substantial distance from one of the parents. So when they agreed on everything else, the faraway parent said, okay, well, let's change the child care provider to somebody in between. So the child has less driving and it's more convenient for everybody. And actually, the attorney for the child came in and said, wait a minute, Your Honor, here I have not one but two studies supporting the fact that if an infant has had the same child care provider from birth, that child care provider should not be changed until the child is at least 3 years old. That's what they come at me with. And I'm like, well, there it is. Well, clinicians, help me out. First of all, I can't take the time and say, well, let's have a 7:30 evaluation over this, because, of course, by the time the 7:30 evaluation is going to come back, the kid's over 3 years old. So what is it? What would you do, Donald? What are you going to do?
So my question really is, you're the judge. If your sense of reality and your sense of what children can adjust to, how resilient children are, is at odds with the material you're hearing, which seems to you to be politicized research, do you ever exercise your own discretion and say, well, this is not clear to me, but this is in my discretion, this is what I decide?
Sure. But I certainly would, it certainly would be helpful to me, and I think for any of us sitting on the bench, to, if I'm taking in or taking judicial notice of some studies, to have somebody, to have Lynn come in and explain the distat side of those studies and the implications of those before I end up making decisions based on urban myth coming from these things. I get that all the time with the vaccination cases. I mean, I have at least half dozen a year. One parent believing firmly, all sorts of research in hand, that if I force her kid to be vaccinated, I'm pretty much, assigning her child a life of autism for the rest of that child's life. And I mean, deeply held beliefs about that, and plenty of clinical studies in hand to back that up.
And that's where knowing the quality of the research is so important, because the quality of vaccination is one of the very few subjects on which the data really is pretty clear. I mean, the guy who thought that vaccinations cause autism faked his data. And when you think about and that's not the same thing as the due process arguments that you guys may need to deal with about each side getting to present their opinion. But the findings that we have, it's not just that they haven't been able to find a correlation between vaccinations and autism. It's that the one person who was supposedly producing all of this important data was found to have faked the records of that data. But that is on one end in terms of the clarity we can give judges, and everything else is in sort of this gray area in the middle where it depends what you emphasize. On the other hand, if somebody comes into you saying, this thing about, they can't be separated from their babysitter before the age of 3, in normal families, people lose babysitters before the age of 3. So whether that's good or bad, given the particular situation and the quality of relationships that these parents have with this child, is a different question. But now, do you want to get some comments?
Well, yeah, I mean, lawyers, what are you going to do? I mean, minors counsel comes up and says, here's some articles. What are you going to do, lawyers? Object? Say, hold on, Your Honor, we'll let you read that, but we want to present? What are you, Diana, what are you going to do? Since I'll probably be in your chambers asking you what I should do. So.
In research that involves studies can control for variables that families that come before me do not. So all I can do is to integrate information from that research, not just the results of the research, but anything that's pertinent in that research to the family before me, and see what I can distill from the information, because certainly all of the variables that they controlled for won't be present in the case in front of me.
Right. Do you think it would help to have a clinician to do that?
Yeah. When we brought this up, speaking about it, if I'm there, minors counsel walks in with a study, and I'm representing one of the parents, and I haven't seen this study before, rest assured I'm going to raise my hand and say, treating it like any other legal argument presented to me at the final hour. It's like, Your Honor, I'd like the opportunity to review the issue and have an opportunity to present to you any contrary authority, if you will, which I think, whether I choose to do that by coming forward with studies that are different, or whether I go to somebody like Lynn and say, okay, tell me what educate me as to what the limitations are on this study, or what other information is out there on the same subject that might change that conclusion.
Okay. Any questions on that before we move to the next scenario? Judge, did you have one?
I was just going to comment on that. I can't imagine that I would ever decide a case, whether on an interim basis, if this is just the first fling into court, or after a fuller hearing, on the basis of me trying to choose between learned articles or studies. Who am I to? I might as well do the internet research myself. If I'm going to make any decision based on studies, I need somebody to interpret them for me, to tell me whether the American Journal of Psychology is actually a credible credible peer-reviewed journal sort of thing, or whether it's some fly-by-night outfit. I don't know these things. So I'm going to be looking for professionals to interpret. I won't make any judgment call on my own based on somebody's research that they brought in.
Well, I think that's the point I'm trying to make, which is there are some bench officers who would be very sophisticated who could do the analysis that Diana would do about pulling those items out. But as the person who's presenting the evidence, I have to make sure that it is being presented in a way that is understandable. And I think we sometimes overlook the potential of having a mental health professional come in to testify about a discrete issue that's not in the context of being a custody evaluator, but educating the court on an issue that's, which is the purest form of expert testimony, which is here's an area of expertise. I can qualify to testify about this. I have an opinion based on the information that's provided to me. I think that's much more helpful to the court on balance than me sticking 6 articles to my request and say, the research supports my position, so rule for me.
How many of our clinicians have, rather than just done a 730 evaluation, have been called upon just as an expert witness on a particular issue? Okay, I can't imagine with the economy being the way it is that we're not going to have more of that. We've had it in Los Angeles for years with something called solution-focused evaluations, where they handle more discrete issues in more a mediative, mix of mediative and clinical way. But I can't imagine for people who don't have the time or the money to spend $25,000 on an eval, if they need to get the court information on bonding, attachment, weaning, also all the kinds of things that we see present in all of these vignettes, it would be surprising to me if we were not moving to a phase where you're called in, you're qualified as an expert on the stand through the process of voir dire, like any other expert witness, and you're going to give testimony on that issue. So I think it's something for clinicians to have some heads up about.
Before we move to the next one, I'm going to give you one hand and ask a question. Some of you have been called on to testify on a pure basis. Among the attorneys and judges, how many of you have seen or been clearly aware of our science, our research being used to inform the interventions that we do with people? Inform the co-parenting, the co-parent. Wow. Yeah, one. Diana's certainly seen it, but not frequently coming to you in the courtroom, right? And how many of you have seen therapists thrown at cases just without a lot of rhyme or reason to the plan? Let's just put them in therapy. Okay. So holding that thought in mind.
I'll read vignette number 2.
Okay.
Father and mother separated a year ago. They have a 12-year-old son, Peter. Father states his reason for leaving Paulina was that she was abusing alcohol and that Peter chose to reside with him. Mother and Peter had a strained relationship at the time of separation, and she did not attempt to contact Peter for the first 6 months after Peter moved out with Father. Mother states that during that 6-month time period, she spent time receiving treatment for stress and depression, but denies being alcoholic, and now wants to resume her relationship with her son. Peter has been reluctant to spend time with his mother. He states that his mother is a drunk who has embarrassed him in front of friends. Mother requests that a conjoint therapist be appointed and be established for her to spend time with Peter, as well as regularly scheduled telephone calls. Father further maintains that mother has not admitted her problem with alcohol and that Peter should not have to spend time with his mother against his wishes. Father also states that the parenting time schedule being requested by mother would interfere with Peter's activities. Would interfere with Peter's football schedule, which mother would know if she had more knowledge of Peter's activities. Mother claims that Father is withholding this information and requests that Father require Peter to cooperate with conjoint therapy and respond to his mother's phone calls. Father expresses concern that mother will again drink excessively with Peter in her care. Father believes that Peter should be allowed to address the court directly, and the court should follow Peter's wishes.
All right. So you're the father's lawyer?
I'm the father's lawyer.
Okay. And be wary, one of you is going to be the mother's lawyer. Yeah. So what do you do, Mary Catherine?
Okay, well,
there you
this
go.
one I'm not so fast to run to court because
I appreciate that.
I'm controlling the custodial schedule. But I'm going to have to talk to Dad a little bit about whether this decision to let Peter decide everything that's going forward is appropriate. And I'm going to have to talk to Dad about the fact, at least under California law, you've got a mom who drinks, but I don't have a DUI. I don't have any documented, I don't have a treatment, I don't have anything that's going to allow me to go into court, ask for testing, really give me a basis for controlling visitation in any meaningful way. So I have to figure out what I'm going to do with that issue. But the drinking from my client's standpoint and from Peter's standpoint is a real issue.
Let's make Richard go solve and be mom's lawyer. Okay, so mom was depressed and she was stressed out. And now, and maybe you suspect, as mom's lawyer, that she was medicating her depression with alcohol, but now she's on antidepressants. Only in order to bring that information to anybody, you're going to have to waive privilege. So, what do you think?
This is one of those instances where I go to the client. This is one of those instances where I go to the client, and even though I am as aware of the privilege in California, which is a pretty strict and rigorous privilege, I'm going to go to the client and say, look, the pitch you may want to make in this instance is one of the reformed sinner, where you say, yes, I acknowledge I had some issues. They may not have been the issues that Dad said I had, but yes, I had some issues, and what I am doing is appropriately addressing them. Yes, I am seeing Dr. So-and-so who has prescribed an antidepressant, and I'm taking my antidepressant, and I'm regularly seeing Dr. So-and-so. In fact, here's my record of appointments with Dr. So-and-so, and here's how I'm taking my antidepressant meds, and I'm much better since then. And incidentally, when I say that I'm not getting this information from Dad, here are my efforts to get this information from Dad, and here is the absence of information I'm getting back from Dad. What I do with the alcoholism issue depends in part on my sense and the additional data I get both from Dad's lawyer as to Dad's allegations in that regard, and from my own client to the extent that my client is willing to be disclosing with me as to whether or not it looks objectively as if there is an issue there which she might also then want to be addressing, even if in her view it's not an issue.
Are you going to go, so either of you guys, are you coming first to me, or are you going first to His Honor?
I think I'm coming first to her therapist, very possibly, and then possibly to you, or maybe to you first and then her therapist. But I'm going to need to have a sense of whether or not Mom essentially went off the rails and it was a situational, aberrant situation, in which case we have to figure out how to get her back on the rails and how to reestablish her relationship with Peter, or if Mom has got an ongoing problem and it's going to be much more difficult to get Peter back into an ongoing relationship with Mom until Mom addresses that ongoing problem. And one of the things that's going to be concerning to me is whether or not there is some sort of interaction between Dad and Mom that essentially allows Dad to push Mom off the rails repeatedly. Because that is not uncommon, where because of the nature of the relationship that they had, the one person to whom Mom is most reactive is Dad, and unless we can get that pattern short-circuited, anytime Dad sends what appears to be a relatively innocent parenting communication to Mom, Mom is going to come unstuck. And we don't want Mom being unstuck.
Do you want to comment before I say what I would do?
Why don't you, I'll follow up.
Okay, so the first thing I'm going to do is look at the issues that nobody's talking about. It's really interesting because we've all talked about the alcohol. I'm getting some nods around the room. Are any of the other psychologists noticing this? That we are all on the alcohol here, and we have not dealt with the fact that we don't know what the situation was when they were separated. But if there wasn't high conflict before the separation, and the separation is mucking with Peter's life, he may be angry anyway. We don't know if he played football beforehand or if Dad is using football as a way to keep Mom there. And the most important thing that I want to know is, did Mom actually embarrass Peter in front of his friends? That is more important to me, coming in from the perspective of the child, than anything else, is what happened that Mom did, and when did it happen? And has anybody addressed that? And is Mom sufficiently back on the rails that perhaps with a monitor or a friend to help her if she sees Dad or whoever, Mom can start attending football practice so that she has something to talk to the kid about. There's no restraining orders here. So that she has something she can talk to the kid about other than what they're angry at each other over. And she can, and why doesn't she know when the football practices are? Is Dad the only one who has access to this information? I mean, Mary Catherine can certainly get an order from probably any of the judges in this room to release the football schedule if Dad really is the only one who has it. If it's associated with the school, then Mom may be able to get it through the school. So that's one of the most important things I want to know, because you may have a kid who felt abandoned by his mother either beforehand due to the depression or the drinking, or afterwards. And you may also have a dad who was more, Mom was doing the limit setting before the separation, Dad was more indulgent, they had more in common, they both play football, and so you have a situation where even if there isn't actual alienation or undermining going on, there's certainly a setup for that, because Mom has some real issues and Dad's resisting them. So you want to know whether Mom actually was a risk and to what degree that's resolved. But you also, I want to know about all of these other things that could create a basis for intervention. And obviously I share the concern that, the other thing developmentally is that 12-year-olds often avoid emotional issues. So if we allow Peter to continue to avoid resolving, one of the things we do know from really robust research, and not just in family law, is that children need to learn to communicate directly and resolve issues in relationships. They need to be able to say, I need, I want, I hurt, I like, I don't like. And that sounds pretty 4-year-old, doesn't it? To be able to say that? How many of us have seen 12-year-olds who have not mastered that preschool level skill? And even if he's doing okay on the football team, there's lots of relationship problems ahead for this kid if he does not learn to master those abilities. So those are the things that I'm going to be saying, what are we putting in place, to whichever attorney hires me. I'm going to say, what are we putting in place to address those issues? And if we allow Peter to continue to avoid these emotional issues for the next 6 months while an evaluation is completed, heaven help the conjoint therapist.
Okay, but I'm going to cut in here from a dad's standpoint, which is, let's assume that Dad, because he's there on the ground, knows that alcohol situation is serious. She could be a closet drinker. We appreciate that some of it could be situational, but don't you have certain risk assessments? Like, yes, we have these alienation issues, but if you're talking, Dad has legitimate concerns that when Mom's out in the middle of the day with the kid, she's had a few pops at lunch, it's like, what do we do about that situation? So I appreciate all viewing it from the alienation standpoint, but right now you have a 12-year-old kid being somewhere with his mom, and Mom has alcohol problems, and in the hypo, Mom's not owning that she has alcohol problems, and Dad's saying to you, she has an alcohol problem.
To be clear, I wasn't just viewing it from the alienation issue. I was talking about, remember, the first question I asked was, what did Mom do to embarrass the kid? Which would mean that it's not necessarily such a closet drinking issue. And, we're talking about Mom having released some of her treatment records, and you would probably want to have a situation where somebody could look into how she's functioning at work, how she's functioning in other situations and whether there's evidence that she's continuing to have trouble.
Well, I think everyone went to the alcohol issue because we have a factual discrepancy on a basic physical safety issue. And we also have a 12-year-old who's a percipient witness. And I have an awful lot of my colleagues using just this kind of situation to justify putting children on as witnesses. Because you have a child in this scenario who's a percipient witness who can let the court know whether, well, mom has been drinking. I've been sitting home at night watching her drink. And yes, ma'am.
Commented that we don't have a baby here. We have a 12-year-old who, if mom is drunk and passed out on the couch, can make himself some mac and cheese and do his homework and go to bed. And he can say, I'm not getting in the car. I think there's a difference between her embarrassing him, which is an issue they probably have to work on, and safety factors. Because I don't think we have safety factors here.
Right, that if she's done it in public, then that may lead you to the other information.
Yes.
That's okay. I guess I understand where Dr. Greenberg's coming from and looking historically at what mom's done and going prospective. The way I would handle it in our jurisdiction is I would be telling, if mom's my client, you're going to alcohol test at the time you pick up the child, and you're going to ETG test, which will test back 72 hours prior to, right after you have the child. That gives dad the security he needs to know that mom's sober. If mom tests positive in any of those realms, well, then you've got your evidence. If mom won't agree to that, then I think dad has a legitimate issue, and she's got to make some decisions.
Okay, so if anybody comes in without any evidence except their say-so and says the other parent drinks, mandatory testing, and you draw conclusions if they don't take the test. That's pretty harsh, huh? Judges, that's pretty harsh, huh?
No, I was saying, well, but what I would do
there's no other evidence except dad saying this.
Correct, but if it's historical in the marriage, our bench will accept what that parent is saying and will order that as protective measures for the child if they're going to give that parent parenting time.
And the other parent says, wait a second, he's making this up. I have never had an issue with
drinking. The court
drinking.
will say then, unfortunately, it'll be an inconvenience for you for a little while till you prove up otherwise.
Okay. Correct.
Here we are. Disproving a negative. It's like a fear of flight. I have a client that's from Egypt. Egypt happens to be a country that doesn't follow The Hague. He's lived in Calgary for 15 years. He has no intention of taking his kids back there. They're Muslim. That's where they've been born and brought up in Canada. And yet mom comes in and says fear of flight. And everyone goes, well, Egypt, so now we disprove. How do you do that? It's the same in this situation. Dad's saying mom's got alcohol issues. I certainly don't see enough here for this child not seeing mom. I really don't. Right. And if I was mom's lawyer, I'd be getting them into reconciliation therapy. That would be my first application. And you just can't disprove a negative. She shouldn't have that obligation.
I think I interrupted her with something. Let's let her go back for her what she's going to do from Dad's perspective, and then I'll talk about that.
I want to know, from Dad's perspective, are you going to ask me or the judges to put the child on as a witness?
I'm not going to put the child.
Because after all, the child may be the only person who sat around in the evenings and can testify to the fact that mom sits and drinks herself to sleep every night. Maybe the only one.
I might find that if my alternative, and I'm representing dad, I'm going to try to find a way to get this child's story to the court by an evaluation. I'm not going to do that. My preference would be not to put that on as testimony, put the kid in the middle. Whether I have to have minors counsel find some other way to get that evidence before the court, I'm going to think through that process, especially if I'm representing dad and I have the benefit of time on my side, and that's what's central. If mom's coming in, the other way the scenario goes is mom is an alcoholic, but she's a functioning alcoholic, and she's never going to admit it, and nobody's caught her, and she's going to sit there and fight, and dad's railing against, I I know she has these issues. And from the standpoint of my client, I don't know whether he's a teetotaler. I don't know whether he's just intolerant of alcohol. I don't know whether he's pissed off. But if he's telling me the kid knows, then it's going to be a vote.
I want to point out here for a second that when you have a court-structured, some of the stuff that we've written about in other things, a court-structured, a highly, highly structured, potentially with some level of reporting requirement, conjoint therapy situation, you have longitudinal information. So if either dad's intolerant and unwilling to support therapy or mom is still drinking, a longitudinal basis of information, and of course the primary purpose of therapy being the opportunity to address those issues, may give you a whole lot more than a 3-hour or 2-week or whatever evaluation by anyone. So I want to know from the attorneys in the room and from our mother's counsel and dad's counsel, are you going to ask for therapy? If so, what kind? And are you going to oppose therapy?
Yeah, I'm not going to vote back. I personally, under this fact scenario, and if I wanted to make sure dad didn't look like he was withholding or punishing, I would suggest that fathers support the conjoint therapy between mom and the son, because it would be in a protected environment with somebody who I think could make some progress in that relationship.
That's for the mother and the child to go into therapy together for the purpose of reestablishing their relationship.
Or both parents. Conjoint therapy that is only, conjoint reunification in some jurisdictions, you call it reunification. Conjoint or reunification therapy, especially in a fact scenario like this where both sides may be involved, it's a real mistake to just have one parent in the child ordered into the process. You want both sides involved.
We have a question?
And I'm a psychologist that deals with this all the time. And it seems that the father or somebody might have thought the 12-year-old needed to have some therapy because he's living with his dad and his mother has not attempted to contact him. We have a child here who, for all practical purposes, has some hurt. He probably has anger and he has hurt. And I would want him to have his own therapist, to be supportive as we go through the process of the reunification or whatever that's going to be. I've been on both ends. I don't want the child and the mother to show up in my office and he doesn't want to be there because he's not prepared. And the mother has not acknowledged, I haven't heard anybody say, Mother, why didn't you call this kid in 6 months? Why didn't you text him? Why didn't you go to the school and have lunch with him? Why didn't you check with the school counselor? Why didn't you get on the website and find out about the football activities? She dropped the ball.
Well, I think that's absolutely true.
Now, Dad may do something in this too. He may be, but this is a 12-year-old who can speak. I would agree with Dr. Greenberg. We missed our 12-year-old. Not pleased.
Sure. I just want to make a couple comments. Going back to the comments you're making about bringing a child into the courtroom or into your private chambers, I think it depends on the jurisdiction. I practice up in Canada, and I know for the province I'm in, practicing 28 years, most of the judges in the lower court and the high court would not allow that to occur. And I think in all the years, it's been 2 times that I've had children being brought into the judges' chambers to talk to the judge. So sometimes in cases they'll have a court-appointed lawyer or an attorney for the child that will provide information as another tool to assist the court. So that was one comment, because I see there's differences. And the other comment was the lady over here who was mentioning about, I guess, a urine test or whatever test you would call it. And I saw you raise your eyebrows because, again, I think sometimes it's thinking outside the box. I've used those cases and done them numerous times representing either dad or mom. And sometimes my feeling is to say to my client, if I'm representing the mom, that's the concern. The alcohol is there. It's the elephant in the room. So let's deal with it. Are you willing to go, we call it the P test? It's going to cost money. So our argument is who's going to pay for it? $100 each time she goes, once every week, once every 2 weeks. Yeah, I'll do it for a while to get the dad to sort of have some level of assurance that I have beat the problem or I've taken care of it. And that's sometimes a way to work it out by even putting it into a court order and then have the judge rubber stamp it. The alternative is to say no, go to court, and then we don't know who the judge is. It might be someone like you who might say, what I'm going to do is order that if you want to see the child for a certain period of time, you will go and have, maybe you can or maybe you can't. So that's the risk of going to court. But if you can get that done in advance, maybe that will give some level of assurance to the dad, who's the one who's saying no, she's drunk or she's causing problems. And the other point was the lady who was sitting back there was talking about a younger child. It's more of a concern for a child 3, 4, 5, 6, 7, 8 than a 12-year-old who can, say, when come home, I know what the difference is between root beer and whiskey, where the 6, 7-year-old may not, and the risk is that the parent, in this case the mom, could be driving under the influence. And that would be the fear.
But then again, as a 12-year-old, we get into the issue is the judge. We have one parent saying, I don't drink, the other saying she drinks all the time. And who's the witness to it? We do have a verbal 12-year-old who knows when a shot of whiskey is poured in a glass and drunk. We do have that. And as we currently, I know in Los Angeles, are going through a very wrenching period. There are differences of opinion on whether to include children as witnesses and under what circumstances, and there's a grave difference of opinion. There's a difference of opinion in this room as to when to do it or not, and when to interview them or not. And that is I mean, if I have the other parent saying, yes, I often use Teen Al-Anon, and I get them involved, and I get education for the child on recognizing when not to get into a car with somebody. So I use Teen Al-Anon a lot. But that's when I get to the issue past your issue, when I've made a finding that alcohol is a problem. We're at the point now where nobody's admitting that. We have parents battling for custody, and each of them pointing out the worst thing they can possibly think of about the other parent. And so she got drunk at an office party 3 years ago, and that's it. She's an alcoholic. She drinks all the time. But I have no evidence of that.
We need to move to number 3. Did you have a closing comment, son? All right. Yes, sir.
Go back a long way, but I seem to recall Kelly suggesting that a child of this age is very likely to consolidate his anger and may very well be opposing the parent who, prior to whatever the breakup was the parent who he was most cared about. Where's the research on what's going on with this 12-year-old?
That was what I was talking about in terms of the fact that children at age 12, that this kid may have other reasons to be angry at his mom. That's why I said the first thing I want to know was what happened that she embarrassed him and what was going on otherwise in terms of the relationship. 12-year-olds may also slant. I mean, we don't want to assume that if we bring the kid in to talk that you're going to get the unvarnished truth. Not only can 12-year-olds be influenced, but 12-year-olds may have their own agenda if he's been led to believe that he's going to have to quit football if he has to see his mom.
So here it is. If I do use the child as a percipient witness, we then have evidence to cross-examine the child with, which may call the child's credibility into account here. And frankly, my belief on this personally is that any child in the midst of extensive parental conflict is suspect to me as to how they're reporting.
But in answer to your question, Don, yes, 12-year-olds do pick sides. Let's go on to number 3. Should we pick on someone else?
9-year-old Sally is considerably overweight and has a history of eating in response to stress. Both parents have a history of weight problems, although after the parental separation, father lost 70 pounds and became heavily involved in physical fitness activities. Father raised this issue with Sally's pediatrician, who confirms that Sally's weight is in the 98th percentile compared to other children her age, and that she is at the risk of developing diabetes. Sally's pediatrician recommends that the parents arrive at a plan to address her weight and encourage a healthier lifestyle, including daily exercise. Sally's mother believes that the pediatrician is exaggerating the problem, and that in any event, Sally's stress-related eating is a response to her parents' divorce and the fact that she must spend alternative weeks with her father. Mother believes that father is overly demanding, demeans Sally's self-esteem and body image, and is overly withholding of both emotional comfort and the food that Sally loves. Father is concerned that if Sally's weight issue is not dealt with now, Sally will face self-esteem issues and the health problems that come from entering adolescence with a weight problem. He proposes implementing the pediatrician's recommendation for exercise by requiring Sally to participate in a team sport. He will allow her to choose between soccer and baseball. Sally is resisting this. Father believes that Mother is sabotaging these efforts by allowing Sally to spend extended time playing video games and giving her the wrong food. Father believes that the parenting plan should be changed to have Sally spend 80% of the time with him so that he can maintain these activities. Mother proposes that Sally attend psychotherapy to help her better deal with her stress, particularly the stress of Sally's relationship with her father. Mother believes that forcing Sally to be involved in a team sport is an invitation for Sally to be targeted by her peers and will leave Sally hating exercise for the rest of her life. Mother requests primary custody of Sally so that Sally can be in a more emotionally nurturing environment.
And whose lawyer are you?
I think I'm mom's lawyer.
Okay.
So I'm mom's lawyer, and first thing I think I'm going to want to do is put Sally in therapy as suggested by mom. What am I going to do if Dad resists that?
Yeah, or if Dad says it's fine for her to be in therapy, but I still want her in my custody so that she can, you know. Or I want, what would be like the judge? I want the judge to order that she choose between soccer and baseball. Because I know from, you know, some of my favorite judges that that's what you guys do, you know, is pick extracurricular activities. So what, yeah, okay, so. Yeah.
So, if I'm mom's lawyer, I'm going to get Sally into therapy as my first level of attack and get into something to address that issue. I think probably the person in this scenario who's more likely to try to take action is going to be Dad, because he's on the plan to move things along.
And are you going to go pick your own therapist for Sally to see? Are you gonna, as your self-defense tactic, have mom go interview and pick a therapist and then go to the judge and say, here, I already have her in therapy? This is not only slightly litigious. We have 10 minutes.
Well, if I think it's going to be a litigated matter, I'm not going to go have mom handpick the therapist and interview them. I might suggest that we come up with a list of people or check with their health care provider, assuming they have insurance, to see. That's one of the first places you may want to go, because you can hear people screaming already. It's like, well, she can't go to that therapist. We have to go to somebody who's on the plan, et cetera. I would explore. I'd have mom dedicate her efforts at the outset of looking at those options.
All right, so the folks have their hands up. I'm going to first go to our speakers, and then what time we have left, we'll go back to the audience, and we're happy to stay and talk with you afterwards. So, Your Honor, it comes to.
Well, I'm going to first try to assess how much this is an education issue. I recently had a case that came back like 3 weeks in a row, a very upset mother, and she wrote to me in her pleadings, unrepresented litigants, that she needs to have this child because the child's being starved. If the child was living with her, she would feed the child healthy things like pancakes, fried chicken, and meatloaf. And this was totally heartfelt. Totally heartfelt. She could not comprehend how feeding the child vegetables and salad was nourishing. So the first thing I'm going to look at is how much of this part of the equation we can deal with an educational model. And I'm absolutely going to use therapeutic intervention because the eating is, in most cases, I would guess that the eating was an example of some other underlying issues that are going on, at least the overeating. And I would make fast work of the video games. If you all came to my chambers, you open a drawer and see a whole collection of video games. The parent was ordered to keep away from the child and couldn't. So they end up in my drawer for a while.
Now, would you take them away, or would you try first?
No, I try first to forbid them. I try first to forbid them. But when it's clear that they're not being taken away, Okay.
So the one place that I would offer a suggestion to that intervention is that personally, having had this scenario, Dance Dance Revolution is the greatest invention in the history of mankind. First of all, if the kid is already hooked on video games, all you have to do is change the video games, and you can take them away every week, and the parent can buy them a new one or borrow them from a friend, or the kid cannot come home. But if you put a catalog, if what the parents do is put a catalog in front of the kid, and instead of forcing the kid to choose between getting tortured by peers at soccer and getting tortured by peers at baseball, the kid has to choose between a menu of exercise videos and what the parent is required to do. And you may have parents here who have trouble setting limits, so you want to give them, put them in parenting intervention anyway. But what what's being asked of the parent is not that the parent take away the video game, but that the parent require that the kid do the exercise video for 45 minutes before they do another video. And a good therapist or a good counselor or a good pediatrician can help the parent do that. Among other things, grown-ups look really stupid during those games. So with the kid this age, an added benefit to doing the exercise program at home is if you can get mom and dad to do it with them, because nothing is as attractive as an activity that makes your parents look stupid. So that would be one of the first places that you might go in terms of the all or nothing, that maybe you want a more moderate approach. In terms of therapy and the insurance coverage, I want to address that just for a second. Weight control is one of the areas where insurance coverage is actually relevant. That's one of the reasons that I included this scenario, because the insurance companies have already figured out that it's cheaper to help kids control their weight than it is to deal with the consequences of them not doing that. So some of the managed care organizations will have groups, they will have individual therapy for this. What they will not have, and here's where you may need a consultant or an expert of your own, they will not have someone who knows that having one parent or the other do all the transportation to therapy is a really bad idea. And here you may need a therapist who moderates the influence of both parents. So you may need a judge who orders that the parents alternate in bringing the kids to therapy. And now I'm going to shut up and let my last few minutes.
Well, do we have any other questions quickly? Because we're almost out of time. We had some questions. Okay.
I guess if we're talking about the psychological aspect of this, what is the psychological research?
The relevant, yeah, and then I was butting over a little bit because I'm afraid I'm stepping on my partner's time here. The psychological research that's relevant, there's also medical research that's relevant. The medical research that's relevant includes the research about what the consequences are of obesity in children. The next piece of psychological research, which is what led to the intervention that I was suggesting with the video games, is that a small change in behavior is easier to achieve than a large change in behavior. So if for a parent with marginal control over a kid, telling him to take away the video game may be a mountain that's really too high for them to climb. It may just lead to a kid who they can't play the video, so they turn on the television and eat, or the parent comforts the loss of the video game by doing that. The science tells us that small changes in behavior, a change of behavior that's like a flight of stairs rather than climbing a mountain, is a much better change in behavior. The third piece of the psychological research tells us is that a negative is much more difficult to teach or reinforce than a positive. So if I tell everybody in this room not to think of the words pink elephant, how many of you, anybody who doesn't have the cognitive control techniques is not necessarily going to be able to do that. If instead you put in the positive suggestion, find X video game, and have the kid do that, that's going to be easier to achieve. On the obesity issue, His Honor's correct. There are lots of times when kids eat in response to stress. There are genetic issues that do that. And there is also plenty of merit to the suggestion that if the response that you do is overly punitive and controlling and doesn't engage the kid at all, you are risking the kid flipping in the opposite direction. So again, you need to look at like the broad range of coping behaviors. That answer your question? Yes. Okay, now other.
Okay, one more question in the back. No? All right.
Any closing comments from my fellow? We got 3 minutes, and
okay.
What else would you do?
Well, certainly I would have the parents consult with the pediatrician, or if they have access to a health plan, consult with a nutritionist. In Los Angeles, I can't be ignorant of the cultural facts, the things that some of us from different cultures may find as, quote, healthy food, or food that's not healthy, is a staple of some of the diets from some of the various cultural groups that we deal with in Los Angeles. So I have to work with that as a norm. So there's lots of stuff that comes into play. It's not so easy as go lose weight.
Right. I think it has a lot of, and we had talked about this before, I think how people approach this issue a lot depends on what their personal history is. Some people might, I was a chubby teenager, you'll get over it, versus, there's a lot of that dynamic in this, and I think when I'm looking at this now, it's like, would I feel differently about this scenario if Dad all of a sudden had adopted a raw food diet? Mm-hmm. And now was this absolute zealot, and, the kid had weight problems, and they're eating maybe not the model diet, but not a terrible diet at the other house, and so they go to McDonald's once a week. That dynamic changes, but everybody, so depending on your point of view on this issue, I think this is, of the three, I found this the most volatile, because I think it's, what if the kid's at the 75th percentile and not the 98th percentile? It's one of those you have to, it's sort of extreme, but you have to think about what do you do in the situation when at the end of the day, to me, the kid is suffering over something.
And the kid...
I'm certainly going to try to work with the custodial parent that's in place to try to ameliorate the behavior before I consider shifting custody.
And that's where you want to really make sure not to go with the cheapest option in terms of your therapist, even if you get a primary therapist who costs you a little more and other managed care resources for the other pieces. And you want to make sure that even if you're getting a therapist on the insurance plan, that the parents are paying a little bit so that the therapist can talk to the pediatrician and talk to the other interveners who are in place. Because my other favorite judge who's in this room tells me all the time that the courts have limited power to micromanage the lives of litigants, and that there are certain things that you can't, do you order, the diet for children? And so you're going to be better off in this situation if you have skilled clinicians in place who can do it, because the research of all the things we're talking about, this is going to quickly become one of those situations where the research over which it's a real problem is quickly going to become unquestioned research. We are not going to have, for long, real scientific arguments over whether obesity is dangerous.
All right. Thank you all.